Do you acknowledge that rioters on January 6th sought to stop this process to prevent Joe Biden from being the president? If that's a yes or no question.
So I understand that the counting of electoral votes was interrupted on January 6th.
Well, you're not responding to my question. Can you define for me what constitutes woke ideology? You wrote it. You meant something. I'd just like you to tell us what you meant by that. I think it would be good for us to know what you mean by what you wrote, and you're not going to respond. So, okay, there you go.
A judicial nominee once called for conservatives to fight the woke ideology and the radical left. Now, Senator Mazie Hirono wanted to know exactly what he meant and whether his past work representing Donald Trump could affect his impartiality on the federal bench.
Smith, on July 30th, 2024, you wrote a post on Breitbart endorsing a Missouri Attorney General candidate. Do you recall that post?
I do, Senator.
So in that post, you wrote, quote, Republican attorneys general are critical in the fight against the radical left. We need true conservatives to defeat the abortion industrial complex, the lawlessness plaguing blue cities, and the woke ideology invading our schools, end quote. Can you define the word woke?
Senator, I was very proud to support my friend who was running in that election. That was a piece of political advocacy, and as I was explaining to one of your colleagues earlier, the partisan views or political activity I've had before would play no bearing on my role as a judge.
Well, you're not responding to my question. Can you define for me what constitutes woke ideology? You wrote it. You meant something. I'd just like you to tell us what you meant by that.
Yeah, Senator, in the course of a political campaign, that was a piece that I put out in support of my friend. But as a judicial nominee, I don't think it's appropriate for me to start commenting on political views because as a judge, I would not be applying those partisan or personal views while I was on the bench.
Well, the thing is that this whole idea of woke ideology and DEI, the president has issued an executive order telling all of his administrative agencies to eliminate any support of DEI. And so you're going to get cases that use terms like woke or DEI, et cetera. And so I think it would be good for us to know what you mean by what you wrote. And you're not going to respond. So, okay, there you go. You've been asked a number of questions by a number of my colleagues about who won the 2020 election, and you testified today that it is the Electoral College that matters in determining who is the president. So the House and Senate was in the process of certifying the electoral votes on January 6th. Do you acknowledge that rioters on January 6th sought to stop this process to prevent Joe Biden from being the president?
On April 30th, the Senate Judiciary Committee voted 15-7 to advance his nomination to the full Senate. Then on June 15th, the Senate confirmed Smith to the 8th Circuit by a 48-43 vote. So the concerns raised here about whether a former Trump attorney could serve independently were ultimately followed by a lifetime federal judicial appointment.
If that's a yes or no question.
So I understand that the counting of electoral votes was interrupted on January 6th. I want to be very careful in getting beyond too much farther beyond that because there is still active litigation.
I think it's pretty clear what the rioters' intents were, and in fact, if you don't want to, you won't answer that straightforward question. I have another one. Do you also acknowledge that a number of these rioters, some 1,500 or so of them, were convicted, and that President Trump pardoned them? Do you acknowledge that fact? Yes or no?
I think that is what happened, Senator.
So you represented. I'm glad that you actually acknowledged a factual question that he pardoned all these rioters who are very intent on beating up our police here and trying to stop the counting of the Electoral College. So, Mr. Smith, you have represented President Trump in multiple lawsuits in which he has been found liable for defaming and committing sexual battery against E. Jean Carroll. In these cases, you represented the president in his personal capacity. If a case comes before you in which President Trump's personal interests are heavily implicated, will you recuse yourself?
On June 15th, the Senate confirmed Smith despite Democrats' concerns about his previous representation of Trump, including his work in the E. Jean Carroll litigation and Trump's presidential immunity case. The final vote was 48 to 43, with Senator Lisa Murkowski joining Democrats in opposing confirmation. Smith is now a federal appeals court judge, meaning the recusal question raised here is no longer hypothetical. It can arise in actual cases before the Eighth Circuit.
Senator, I've been very proud to represent the president.
Well, will you recuse yourself?
I will recuse from any case I've been personally involved in. For any other case, I would consult the judicial canons and the appropriate recusal rules. I may need to consult with my colleagues.
Well, considering the kind of representation that you've provided President Trump, you do cite the canons of ethics and the Code of Conduct for United States judges requires a judge to disqualify himself, quote, in a proceeding in which the judge's impartiality might reasonably be questioned, end quote. I would say that in any case involving President Trump's personal interests, you should recuse yourself because it is very clear where your loyalties lie.
On June 15, 2026, the U.S. Senate confirmed him to the U.S. Court of Appeals for the Eighth Circuit by a 48 to 43 vote. The Senate's official record confirms the vote, and Smith's confirmation followed a Senate Judiciary Committee vote of 12 to 10 on May 14th. The confirmation came after senators had questioned Smith about his political advocacy, his previous representation of President Trump, and whether he could remain independent on the bench. Smith had acknowledged writing a July 30th, 2024 Breitbart article supporting Will Scharf for Missouri Attorney General, in which he described Republicans as needing to fight the radical left, the abortion industrial complex, and woke ideology. He was also questioned about his work representing Trump, including litigation involving E. Jean Carroll and Trump's presidential immunity case. Trump had nominated Smith in February 2026, specifically highlighting his role on Trump's legal team. And that is what made Senator Mazie Hirono's questioning significant. She wasn't simply asking Smith about an old political article. She was testing whether the language he used as a political advocate could matter once he received a lifetime appointment to a federal appeals court. Smith's answer was essentially that his political advocacy belonged to his past and that, as a judge, he would decide cases according to the law rather than his personal political views. That is a standard promise made by judicial nominees, but Hirono pressed him on a practical problem. Judges don't operate in a vacuum. They have to interpret statutes, constitutional provisions, and executive policies that can involve exactly the political concepts nominees previously advocated for or against. The woke exchange, therefore, became a test of whether Smith was willing to explain his own words. He had publicly used the term in a political argument, but when asked to define it under oath, he declined, saying that doing so as a judicial nominee would amount to commenting on political views. There is a legitimate argument on Smith's side. A judicial nominee can reasonably say that political rhetoric used during a campaign should not become a judicial rulebook. Judges are supposed to apply the law, not decide cases according to slogans from past political activity. But Hirono's concern was equally straightforward. If a nominee has spent years advocating for particular causes, the Senate has a responsibility to examine whether that history could reasonably create questions about impartiality. The same issue appeared even more clearly when the discussion turned to January 6th and the 2020 election. Smith had previously been involved in efforts challenging the 2020 election results, and during the hearing, Democrats pressed him to acknowledge basic facts about the election and the January 6th attack. Senator Dick Durbin also questioned Smith about his refusal to directly answer who won the 2020 presidential election. That matters because an appeals court judge can eventually face cases involving elections, presidential authority, voting rights, or the conduct of government officials. The Senate, therefore, wasn't merely debating an old campaign dispute. It was considering whether a nominee's previous legal and political activities could affect public confidence in the judiciary. Hirono also raised perhaps the most concrete issue, Smith's representation of Donald Trump. Smith had personally represented Trump in litigation, and Hirono argued that cases involving Trump's personal interests could create a reasonable question about Smith's impartiality. Smith said he would recuse himself from cases in which he had personally been involved, while saying that other situations would be handled under the applicable judicial ethics and recusal rules. That distinction is important. A judge cannot simply recuse himself from every case involving someone he once represented. Federal judges regularly come from private practice and may have represented major political figures, corporations, or government officials. The relevant question is whether the judge's prior involvement creates a legally recognized reason for recusal in a particular proceeding. But because Smith's relationship with Trump was unusually direct, and because Trump personally selected him for the Eighth Circuit, the Senate debate naturally focused on whether the public could trust Smith to separate his former client relationship from his new judicial responsibility. The later confirmation makes the hearing even more consequential. On June 15th, the Senate decided that Smith met the standard for confirmation, voting 48 to 43. He now has a lifetime position on a federal appeals court, meaning the questions raised during the April hearing are no longer hypothetical. The issue has moved from whether Smith should receive the position to how he will perform it. Supporters of Smith argue that his legal experience, including his work on major constitutional and presidential cases, gives him valuable courtroom experience. Senator Eric Schmitt, who previously worked with Smith in Missouri, praised him after confirmation and said he would faithfully interpret and apply the law. Critics see the same background differently. They argue that appointing a former personal attorney of the president to a lifetime appellate judgeship creates an appearance problem, particularly when the nominee has also engaged in outspoken conservative political advocacy. Those concerns were central to opposition to his nomination. Ultimately, the confirmation vote settled the political question, but it did not settle the larger question raised by Hirono. The real test begins when Smith's courtroom decisions have consequences for the very issues he once advocated about. If he consistently applies precedent even when it conflicts with Trump's interests, his supporters will have evidence that his confirmation hearing promises were genuine. If future rulings create a pattern suggesting that political loyalty or past advocacy is influencing his judicial reasoning, the concerns raised during this hearing will become much more significant. That is why this exchange is worth revisiting now. Hirono was not simply asking Justin Smith to define one political word. She was asking whether someone who had openly fought for conservative causes and represented Donald Trump could convincingly separate that history from the responsibility of exercising independent judicial power. Now that Justin Smith has been confirmed to a lifetime seat on the Eighth Circuit, the real debate is this: should a judge's previous political advocacy and personal representation of a president be considered enough to raise serious questions about judicial independence, or should the public judge that independence solely by the decisions he makes from the bench?